So let me introduce and thank Professor Alan Fraser, that is the director of the School of Medicine in Cardiff at the University of Wales. So thank you very much for being here, and thank you for your presentation. The floor is yours.
Thank you and good morning. I hope you can see my slides.
Yeah, and we can see properly.
Yes, thank you. And I apologize that I'm not there in person, but I've got COVID this week, so I'm gradually recovering. I'm going to give a rather different perspective, I suspect, from the other presentations in this meeting as a clinician rather than a lawyer. And I would like to challenge some assumptions that most people more or less take for granted, which I think could be viewed as conflicts between the provisions of law relating to medicine and ethical needs in routine clinical practice. Next, please. So just to clarify, I'm a clinical academic cardiologist. I've been practicing medicine now for many years. My research interest is in understanding mechanisms of disease and in diagnostic practice for heart diseases. I'm emeritus in Cardiff, but a visiting professor in the Cattolica Universität in Leuven, there where you are. And my interest in this field and overlapping interests come from representing European cardiology and medicine in Brussels at regulatory affairs meetings and fora from the European Commission for about 10 years, and most recently for the Biomedical Alliance in Europe. I chair their Regulatory Affairs Committee, which is representing 36 different medical professional associations around Europe. So although unfortunately the UK made a strange decision to withdraw from the European Union, I am very firmly a European citizen at heart, and I'm very experienced in Brussels medical politics over many years now. And my main role now, however, is to coordinate a Horizon 2020 project called Core MD. It has a website which you can look at, but we are providing regulatory experts in Europe with expert guidance on how to evaluate the clinical evidence for high-risk medical devices. Next, please. So let me start with something very basic, which is the WHO definition of health. It has always seemed to me that this is unrealistic because, of course, as you know, it states that health is complete physical, mental, and social well-being, which means that no one, more or less, is completely healthy. Well, that's not so surprising, but you can have a very good quality of life and feel healthy without fulfilling this criterion. So I'm not sure that this is particularly helpful, particularly since it leads to the definition of attainment of health as a human right. Now, if you look in detail at the WHO definition, it states, of course, not that health is a right, but the highest attainable standard of health is a right, which is a very important qualification, but that is sometimes lost when people talk about health. And I think we need to remember that all of us are time limited and that it is actually access to healthcare that is what is most important. And in many of the new debates about technology and digital healthcare, we have to also remember that it's unequal access to health that is a major determinant of social disparities and inequalities and differential rates of survival currently, and they should be getting more attention, I think. Next, please. It leads on to the basic assumptions of medical ethics, which include the principle of autonomy. Now, I don't want to remove that. Of course, patients should have the right to make their own decisions. But I just want to highlight the fact that in many cases, patients do not want to exercise autonomy. And these are two studies that I did. They're quite old now, relatively, as you can see, published in 1984 and in 2010. If you could click forward twice, please. You will see that in the first one, we found that only 1/3 of our patients wanted to be fully informed about all the risks for a invasive cardiac investigation, cardiac catheterization at that time. Now, there could very well be societal trends that have changed that. But the important point is that we need to recognize that patients have a right to as much information as they wish, and they do not necessarily need to be overburdened with detail if they choose not to know it. And the second study, done more recently, showed that less than half of our patients wanted to be involved in making decisions about their care. I don't think this is so surprising if you consider what you would want to do when you have cancer, or you developed a brain tumor, or you have a heart attack. Do you want the doctor to tell you the choice of treatment is up to you, or do you want them to recommend what they think is most appropriate? And the vast majority of patients do not wish to make the decision. They wish to have the chance to accept or refuse the recommendation, but they need to have physicians who spend time with them so that they can trust them, so that they can understand that there is a decision to be made, but then they want the expert's advice. And that's not always fully appreciated in the public debate about this. It is not often that there is true equipoise in a medical decision where there are two equal options with equally good results, where the patients really can choose. Next, please. So I'm going to go on to discuss some differences between the way that most regulatory jurisdictions, and particularly the European Union, manage new drugs and pharmacological agents compared with new medical technology and devices. And at the top, you will see that new drugs are usually not approved and reach clinical practice unless they've undergone a large clinical trial that proves not just that the drug is safe, but that it is effective for its defined purpose. Historically, the medical device directives, and to some extent the more recent regulations in Europe, are very different because the standard of evidence for a new technology was safety and performance, not effectiveness, but performance. In other words, the device needs to be proved to perform the task that the manufacturer defines for it. Then the device would be given a certificate of conformity by a notified body and have a CE mark for European Union market-wide access. And very often in the past, the major clinical trials, the pivotal trials, were done after the device had reached the market. Next, please. This has led to a lot of problems, but here I want to highlight the difference in transparency, because we can cope if devices reach the market with less evidence, as long as that evidence is in the public domain. Now, the European Medicines Agency, which now approves about 90% or more of new drugs in the European Union, issues all this information through its website, and we reviewed this a few years ago. I won't go through this list in detail because of time, but it's very extensive, and it includes the evaluation reports, all the evidence that's submitted, and the opinions of the experts who have assessed and reviewed the evidence. Next. In comparison, let me show an example. And at the top, you can see an transesophageal echocardiogram on the right top of an aortic valve prosthesis, an artificial valve in the aortic position. And this was a patient who had had a stroke. She had had a blood clot form on the valve that embolized and caused a stroke. And at the time that she presented with this problem, which is a few years ago, her INR, that's the International Normalized Ratio, which is a standard test for the degree of anticoagulation of her blood to reduce the risk of clot on the foreign body surface of the valve. The test was 1.9, whereas normally we would expect it to be, say, 2.5 or more for such a patient. But this occurred just after the company had been advertising that it was safe to use this valve at an INR of between 1.5 and 2. Next, please. So we wanted to understand why this happened, and I won't go through all the details, but please click through this slide so that you can see all the steps and the next one and stop there. So the labeling and the packaging for the valve shows that it was approved by notified body 459. And if you go to the NANDO database on the European Commission website, you can find out that that's GMED in Paris. But clinicians such as ourselves were not allowed to contact the notified body, nor even the national regulatory agency, which in the case of France is the Agence Nationale de Santé Produits de Médecine, I think, ANSM. We can't contact them, so we contacted our UK agency, MHRA, who contacted the French agency, who contacted the notified body, and the message came back to us that there were no concerns. Now, this is completely unsatisfactory when we have patients with life-threatening implanted medical technologies where we cannot get access to the clinical information that may or may not have contributed to the particular complication that we've seen. And in this case, there were subsequently publications that showed that there were many specific conditions for the lower level of INR that had not been fulfilled in our patient, but were not publicly available at that time. Next, please. So there's a major difference between all that information given for drugs and the limited information given for devices, which to me is illogical and a clear double standard. From a clinical perspective, we need the same amount of information for both. One of the issues here is the way that the European regulatory system has been set up, because drugs are evaluated by the European Medicines Agency, which is an agency of the Commission and which therefore is subject to the European law on freedom of access to information. And I've given you the number there, but you're probably familiar with that. Whereas the devolved system of evaluation of evidence by notified bodies under the European new approach for technology means that the notified bodies as independent commercial organizations are exempt from the provisions of the freedom of access information. And that, again, to me, is an illogicality of the system that hasn't been appropriately dealt with by legislative changes. Underneath, I have highlighted, but I won't now go through in detail, two sections from EU 217/745, which is the medical device regulation, which summarizes the confidentiality of exchanges with the notified bodies, which allows companies not to disclose the information that they have to submit for clinical evaluation and approval. Next, please. So the new European system that we and others were arguing for is summarized here in this diagram and in the paper that is referenced there. But the key step that I want to highlight is that the data presented by the manufacturer for their technology is still assessed by a notified body, But now for high-risk medical devices, there is a clinical evaluation consultation procedure called CECP, which reviews the evaluation of evidence by the notified body and issues reports which should be in the public domain and for which there was no provision, as I read it in the regulation, that there should be any exclusion, but all the data should be published. And yet, if you look at the next slide, here is the first report of any CECP under the new system in Europe. And this was a report on a dental implant. And on the left, you see an extract from the report when it was first published, and you can see that it names the product as the ivory dentin graft. Now, soon after that was published publicly, as indeed I think it should have been, the document was withdrawn by the European Medicines Agency and then republished on the right with the name of the particular device redacted. And I really do not understand this. I have not been able to find any legal case to support this. And I think the decision was made after a lawyer's letter to the European Medicines Agency from the company or on behalf of the company without this having been challenged in court. This is another very clear double standard. There's no point in having an open access public expert consultation if the name of the particular product is not released. Next, please. So we did discuss more legal precedents in this policy paper published a few years ago, but I would argue, as with my colleagues we stated here, that from ethical perspectives, there are no grounds for less clinical evidence being available for devices than are available for pharmaceutical products. Indeed, we're all in medicine quite rightly asked to practice evidence-based medicine. And I've heard colleagues state, and I think I agree with them, that if the evidence is not published, then we cannot practice evidence-based medicine, and we may be choosing dangerous technologies, therefore on an unethical basis. So I think these are very important issues that still need to be addressed within the European healthcare system. Next, please. And I'm conscious of the time, so I'm just going to go on quickly with a few other points. On the top timeline here, I've highlighted the sequence of development of new technology from an initial idea and prototype to preclinical testing through to post-market surveillance. And underneath the typical sequence for really innovative technology would be a special encouragement to academics to get new funding for innovation, to protect their intellectual property, perhaps to start up a spin-off company, which would then require venture capital, might become a successful small and medium enterprise, and eventually may be bought out by a big med tech company. Now, at the right-hand end of that scale, society criticizes big pharma and big med tech, perhaps for making excessive profits or for charging too much money for their products. And yet at the left-hand end, academics whose motive is very often not financial, but clinical or academic or societal, they are encouraged to develop companies. And so we have a very ambivalent attitude somewhere along this chain. The attitudes change, and we need to think about that because we do not, we could not practice modern medicine without technology. Whether it is drugs or devices, we are absolutely dependent on all the major advances. But we need companies to have some system for sharing their information about their profit margins, or about being more transparent in what they do so that we can support them, and so that this sequence is slightly more rationally viewed by society as a whole. Next, please. And my last couple of comments, if there's time, are just about digital health and e-health and m-health and all these new phenomena. I'm, of course, not a digital native, and I do not believe in anything called e-health. We do not get healthy by having a piece of technology in our hands. We're biological creatures. Of course, virtually every aspect of medicine nowadays is dependent on ICT and computing technology and all sorts of things. But that doesn't mean that they become the method of delivering the health. They are supportive for what is essentially still a human interaction between healthcare professionals and patients. Now, WHO have published guidance, and here above is their definition of digital health. But I show this slide to highlight that there is a publication from a couple of years ago that found 95 unique definitions of digital health. So I'm not really sure when we use these broad terms what people are actually talking about, and I think we should be much more specific. Next, please. And that extends now to the sea of data in which we exist. If you click forward once or twice, please. Of course, we need to make sense of this, and we now have machine learning and artificial intelligence, which have indeed been extremely helpful and will no doubt continue to increase in what they can do to support us. But I'm one of those who agrees with this publication, which I encourage you to read, stating that artificial intelligence is stupid. It shows associations, but not necessarily causation. Next, please. And AI is now so fashionable in medicine that it has become an objective in itself, which I think is illogical. These are three goals published by the European Medicines Agency in its document last year on the future needs for developing regulatory science. And they're all examples where the technology appears to have become more important than what it is used for, which I fail to understand. If we go back to Marshall McLuhan many decades ago, this is making the medium the message rather than its final clinical application. Next, please. And click forward again. So on the left here, I've shown you the normal sequence that we like to think we're following when we practice rational Western evidence-based medicine. Next, please. But on the right, this is what we're in danger of doing. We're breaking the chain of logical thought by starting with masses of evidence or data, analyzing it with a convolutional neural network, for example, and then trying to work out a hypothesis that explains the findings. And this is not necessarily going to help us because it's not necessarily a causal relationship. So we have to be very careful. It's also a big mistake to talk about artificial intelligence as one subject. It's multiple methods. If you like, you can view it as advanced statistical analyses. And we don't have a European law for medical statistics. So again, how we evaluate these new technologies must be on the basis of what they are being used for and what the implicit risks would be in that occasion. Next, please. So I'm sorry I'm rushing through this because of time, but here is my summary of some of these ideas that I've presented briefly on what I see as potential double standards between clinical practice and experience and the ethical framework that people take for granted and the laws that are being introduced. I think for clinical decision-making, patients need sympathetic doctors and nurses with good communication skills who will share the options and answer their questions. But unless, and that is rare, there is true equipoise, then patients actually ask for some medical paternalism, if you like. They want guidance, which is entirely appropriate. We go to experts for their advice. Secondly, there are standards that are very different between devices and drugs that are illogical. To me, they are to some extent giving too much authority to the commercial interests of industry as against the patient's need for clinical information. And lastly, I referred briefly to some of the trends in new technologies where I think we treat e-health and m-health and AI as single subjects that are universal panaceas, when of course they're not. They have limitations, they have multiple different meanings, and they need to be evaluated individually according to their impact, with extensive consideration of what would be appropriate clinical evidence before they're approved. So I hope that's some thought, and thank you for asking me to contribute to your discussions.
Thank you very much, Professor Fraser, for this very challenging presentation. It was very much interesting. I'm afraid we are a bit late, so we should limit, if there are questions, to maybe a few questions in few minutes. If there is, please, we will collect a couple of questions and
So thank you both for very interesting presentations. My name is Aist. I'm from University of Turin. I have a question to Georgia. You mentioned the DPIA and the GDPR exemptions, and I was wondering how do they work within the context of private and public partnership research? So imagine you have a situation of a public university hospital in a collaboration with a private entity developing some sort of software for medical reasons, for medical research that both addresses the public interest, but also at the end facilitates also commercial interest. So how do you manage those? They're not necessarily competing, but they facilitate for both. Thank you.
First of all, to all the speakers, thank you very much for your very interesting presentations. My name is Daniela Spajc. I'm a doctoral researcher at the KU Leuven. And my question would be for Professor Fraser. Well, first of all, thank you very much for this valuable insight. I think it's a very valuable view to understand, to see again, once again, how much the right to information actually is, especially for patients, and also this idea to that shouldn't be underestimated, to give the right to the patients to actually decide what they want to know and what not to know. You mentioned very early in your presentations that patients do not want to exercise their consent. I was wondering in that regard, and that's a question of understanding, to what kind of consent are you referring to? Are you referring to the ethical consent or the consent, well, the data protection consent, or even perhaps clinical trials? And then I was wondering, as a follow-up question, is that something that you in your clinical practice try to accommodate? So do you try to realize the wishes of the patients? I can understand it's perhaps a bit more difficult with regard to ethical consent, but maybe, let's say, for data protection consent, do you perhaps refer to other legal bases if the patients wishes so? Thank you.
maybe if we want to start with Professor Fraser.
Thank you for those interesting questions. Let me try and be very brief. I was not saying that patients do not want to exercise consent, but they should always exercise consent. But what I was stating was that how informed they want to be before they make the consent is their choice. And I do that in clinical practice. I would, for example, ask a patient, would you like to know more about the risks? And if they say, no, I don't want to, I trust you, I prefer I don't know about the risks, then I would document that they have made that request, because nowadays the situation has changed. And I think if there are real risks, for example, of death, then you need to mention those concepts, but you don't need to give the numbers unless the patient wants to know. So I appreciate that my own personal views are not necessarily the consensus view, but that has been recognized in law, but it's therefore very wise for the individual clinician to record that they have asked the patient and they've done what the patient has requested. And the key thing is that the patient should be given time, the patient should be given the opportunity to answer, to ask questions, and all of those should be answered in detail and fully. But my point is that we have now reached the stage where patients are actually often given too much information. And it's the same with electronic consent now on the internet, where you may have multiple pages. And if you have a health app and you have to sign a form that absolves the app provider of all responsibility that runs to 20 pages on the internet, then we've got it wrong somehow. And we need adaptive consent processes where the patient can control how much information they want. And we concentrate on what's really important and on answering their questions. So that was mostly with respect to clinical procedures and investigations, but you can extend it to clinical trials. And actually, we published a paper recently where we had a 1 or 2 page consent form as an example, followed by questions and answers, because very long forms don't get read, and then you could argue that it's not informed valid consent in those circumstances. For data protection, issues might be different. Each case should be analyzed independently.
Thank you. Maybe George.
See, yes, they in the context of private and public controllers, they create joint controllership contracts, and then they base all the research on the consent that allows also the commercial purposes.
Okay, I would like to thank you both again. Thank you very much for your presentation, and we need to stop for this morning. Thank you very much to all of you as well. See you. Bye. Thank you.